I'm Andy Lester. I am the chairman of the Oklahoma Free Speech Committee. The Oklahoma Free Speech Committee is an adjunct of the Oklahoma State Regents for Higher Education. Our committee was created legislatively several years ago, and its purpose is to encourage and help make sure that free speech rights on college campuses are respected. I'm joined here today to have a conversation about free speech on college campuses with two of the top attorneys in the state. First is, to my left, is Brandee Hancock. Brandee is the interim general counsel for the Board of Regents for the Oklahoma Agricultural and Mechanical Colleges, which governs Oklahoma State University, Langston University, Northeastern A&M College, Connors State College, and Oklahoma Panhandle State University. She has her bachelor's degree from Oklahoma State University and her JD, or Juris Doctorate, with honors from the University of Oklahoma College of Law. On my right hand is Mackenzie Wilfong. Mackenzie earned her bachelor's degree from the University of Oklahoma and did so being admitted to Phi Beta Kappa. And she earned her Juris Doctorate degree from Southern Methodist University. She's held several positions in higher education throughout her career, including her most recent one, where she serves as Executive Director and Secretary for the University of Oklahoma Board of Regents. That Board of Regents governs, of course, the University of Oklahoma, as well as Rogers State University and Cameron University. And let's just get right into the conversation. So I'll have several questions for each of my colleagues here. And the first one goes to Mackenzie. Mackenzie, recent campus protests tied to international conflicts have included encampments, building occupations, and even prolonged demonstrations. How should institutions distinguish between protected protest and unprotected conduct? And what enforcement challenges arise when protests become continuous or semi-permanent?
Thank you for the question. Distinguishing protected protests from unprotected conduct at public universities starts by grounding us in some foundational legal principles, which are simply stated but endlessly litigated. Public university campuses are not enclaves immune from the sweep of the First Amendment. That's Healy versus James, a Supreme Court case from 1972. The Supreme Court there drew the critical distinction between student activities that infringe reasonable campus rules, interrupt classes, or substantially interfere with the opportunity of other students to obtain an education, which can regulate, and pure advocacy, which is entitled to protection. So how do you regulate it? Time, place, and manner restrictions. Public university campuses, particularly areas of campus that are traditionally open. Think quads, green areas for OSU, library lawns for OU, north and south ovals and plazas are generally treated as public forums. Under the doctrine established in Ward versus Rock Against Racism, another U.S. Supreme Court case from 1989, the government can impose reasonable restrictions on time, place, and manner of speech-related activities, provided those restrictions don't suppress the content of the speech itself. And for those restrictions to survive First Amendment scrutiny, you really have to look at three different factors. One, is it content and viewpoint neutral? Two, are they narrowly tailored, right, to serve a significant government interest? And three, are you leaving ample room in this case for students with alternative channels for communication? The viewpoint neutrality requirement is the sharpest tool in a challenger's arsenal. Even when lawfully seeking to shut down a protest, any restriction has to be content and viewpoint neutral. So this question is really where theory meets reality, and I want to be candid about how this can be so challenging operationally. First, you have a timing challenge. A single-day demonstration is easy to analyze. The legal and institutional complications multiply with successive days. So once an encampment becomes semi-permanent, institutions face pressure really at three levels simultaneously. First, you have the protesters who argue that removing them is going to be content-based suppression. Second, you have from other students and faculty who say whatever occupation interferes with the campus community. And three, from legislators or federal agencies who are watching closely for compliance with civil rights obligations as they should. Second, you have the institutional, you got to make sure that the policy precedes the crisis concern, right? A time, place, and manner policy that enforces perhaps a clear and explicit prohibition upon encampments, stating that camping in vehicles or tents or other structures is not permitted on campus. That kind of pre-existing content-neutral policy is legally far stronger than an ad hoc response crafted, say, in the middle of a protest. And so third, the participation versus viewpoint problem. Protesters often mix protected and unprotected conduct simultaneously. Chanting slogans, protected. Blocking building entrances, not so much. Displaying signs, protected. Preventing other students from attending class, also not. The challenge for administrators is that enforcement against the unprotected conduct will look to the protesters, or even to some observers, like content-based suppression, even when it isn't. The legal defense is documentation, right? Institutions need to contemporaneously have records showing that enforcement was triggered by the conduct, that conduct being a blockade, a trespass, an interference with class, but not by the message. The constitutional framework is well developed. When we look at Healy and Clark and Ward, and the public forum doctrine gives institutions real authority to manage continuous and semi-permanent protests. The failures are not really legal ambiguity, right? It's institutional inconsistency. Universities that have clear, pre-existing, content-neutral policies and critically enforce them consistently are on a much more defensible ground than those that improvise responses to specific messages. Those, not so much.
So in other words, it's helpful to have the policy already in place.
I would say imperative. Absolutely helpful.
Thank you. Brandee, let's go to a different area. How should institutions distinguish between employee speech in an official capacity and protected speech as a private citizen, especially on social media? And why is it even important to do that?
Yeah, so I think a couple of things are really relevant here. Mackenzie touched on the foundational legal principles are well established, but adopting them in practice is a lot more difficult, and particularly with social media. Case law tends to lag behind where we are in the technology world, particularly as technology takes off so fast. And social media gives an ample forum that can cause challenges on campuses that really wasn't anticipated by a lot of the foundational case law. So the foundational cases at the constitutional level in this area are Pickering and Garcetti. You're looking at a three-factor analysis. The first question is, was the employee acting as a private citizen or pursuant to their job duties? The second issue is, was their speech about a matter of public concern? And then you get to a balancing test. If the employee's speech was as a private citizen and it was made about a matter of public interest, you balance the interests of the employer versus the interests of the employee. Sounds really simple, right? So each case is very fact specific, and what you're looking at is a number of factors. First one you can look at, and it's much easier for staff than faculty, but was the social media post made during work hours? If it was, you can address the posting itself, not the content, because again, you want to be careful about viewpoint restrictions and not restricting the speech of your employees. For faculty, that's a little harder. Their schedules aren't as set, so that's really not much of an option there. In order to address the behavior, though, you have to show as an employer an actual disruption on your campus, not just an anticipation or fear of a disruption. So what that can look like in practice is, in an extreme scenario, you have students who refuse to take a class from a faculty member because of the nature of what they've said. That's now a potential disruption that's occurred that you can address through your policies and procedures. As this area evolves, a couple of recent cases are worth noting. One out of Illinois in 2025, which is the First Circuit, was a high school social studies teacher. that had a history of disciplinary issues was terminated after they posted on their personal social media account following the George Floyd protests. The school took action to discipline the teacher despite the fact that she could show she did not accept friend requests from new students. Most of her following was former students, parents, etc. What the school was able to show was a disruption caused by the significant community blowback that they received in a relatively small community. And so the Seventh Circuit affirmed the dismissal of that teacher in that scenario. That's a case, an area to keep an eye on and see where that goes in the 10th Circuit and other circuits. And in another recent case that actually was just heard, oral arguments on April 8th out of the First Circuit, this case asked the question whether speech receives less protection when it is mocking, derogatory, or disparaging in nature. And a lot of, I think, what you see on social media and the concerns we hear from people is, well, that's just insulting, it's hate speech, it's those types of things. And this case follows that line. The First Circuit in outside of the en banc hearing affirmed the district court finding that speech does receive less protection. So we're keeping an eye on that one to see where that goes. But the bottom line here is if the speech is on a matter of public concern as a private citizen, you need to be really, really cautious of taking any action in that area and make sure that you can show an actual disruption and, to Mackenzie's point earlier, that you're documenting that disruption at the time it happens so that you have a legally defensible position.
You mentioned the 10th Circuit. Why? Just curious why you mentioned the 10th Circuit.
Oklahoma sits in the 10th Circuit. That's our district. So while other circuit court opinions might be relevant or persuasive in the 10th Circuit, they are not binding on Oklahoma institutions.
Thank you. Mackenzie, I want to go back to something that you talked about. Encampments. Are overnight encampments protected expressive activity? How should campuses analyze restrictions on tents, structures, or occupation of outdoor spaces under the time, place, and manner doctrine?
So, Andy, it may be expressive, but it's not insulated from regulation, provided the university has what we talked about, a clear, pre-existing, and consistently enforced policy regarding overnight camping. The golden rule of time, place, and manner restrictions. These restrictions have to, again, be content neutral, narrowly tailored to serve a significant institutional interest, like, for encampments, safety or sanitation, and leave open ample alternative channels for communication. So there's a case on point, Clark versus Community for Creative Nonviolence, against the Supreme Court case in 1984. And it explicitly held that a ban on overnight sleeping in a public park was a constitutional restriction on conduct, not on speech. Tents, structures, and occupations are physical conduct. And you can absolutely tell protesters that they need to take down their tents at 10 p.m. But you cannot let one group stay just because their cause is more or less controversial. So for a campus analyzing tents, structures, and other kind of long-term occupation of outdoor spaces, you need to kind of reflect and ask yourself the following questions. Is the rule content neutral? Is it tied to safety, sanitation, access, property preservation, or ordinary use of the campus? Is it applied evenly across all causes? And are alternative channels left open? Can they do daytime protests, signs, marches, rallies, literature, and other neutral rules? And if yes, a restriction on overnight encampments is much more defensible than a restriction targeted at a particular viewpoint, which we don't want to see happen.
Okay, thank you. Next topic. Brandee, academic freedom. We hear a lot about academic freedom, and I think most people watching what we're doing here right now are interested in academic freedom. How far does academic freedom extend in controversial classroom discussions, grading practices, or even invited classroom speakers?
That's a great question. And we do obviously hear it a lot on campus. At the outset, it's important to remember that academic freedom is not carte blanche for faculty to say whatever they want, whenever they want in class. As a general rule, I touched on Garcetti earlier, which Garcetti says that speech made pursuant to your official job duties does not get any constitutional protection. And the Supreme Court has not determined whether or not that applies to academic speech. However, several circuits, not the 10th, importantly, have said that there is an exception for academic freedom. So that's kind of the general principle that you start with, is that for the most part, as long as the speech is germane to the topic, it is generally protected under academic freedom. As to grading practices, institutions have a lot more interest in making sure that grading practices are fair, not based on viewpoint, and are not retaliatory in any way. So there's actually some case law that's kind of intriguing here. It says that while you cannot require a faculty member to change a grade, you can institutionally on the administrative side change that grade. So in other words, you can't tell a faculty A, you must change the student's grades, but you could go through the registrar's office to change that if there becomes an issue here. The easiest way to avoid this type of issue is for faculty to have very clear viewpoint neutral grading rubric and to apply that rubric consistently across all of their courses and all of their grading. That keeps both the faculty member and the institution out of trouble. Invited speakers are a tricky issue. Best practice in general is to, if you're going to invite a speaker on a topic that's relevant to your course, that has a really a view that goes one direction, invite someone with a differing view to come a different day. Let them have that dialogue, and that's one of the things I adjunct teach, and I tell faculty when I train, if you're doing your job well, students should never know what your viewpoints are. One of the concerns I do hear from faculty, and I understand it, is the concern about a moment going viral. What if students are recording me, and what if I'm playing devil's advocate? And so that's not even my view, but we're arguing because we're challenging students to think critically. And that's a real concern that faculty are facing currently, and you see it play out at the real world level. So I think it does present some really interesting challenges there. And then one final note on inviting speakers, it'd be good to have the speaker give a disclaimer that they're there in their own capacity. They're not speaking on behalf of the institution. I know we as practitioners often do that when we're training, just to make sure it's our view, it's not that of the institution that we represent.
So are you saying that your views right now are
I am
those
speaking
of
as
yourself?
an individual person and not on behalf of the A&M Board of Regents.
I kind of thought that would be your answer. Mackenzie, how should institutions address speech generated by AI tools, such as flyers, deepfakes, impersonations? Does the use of artificial intelligence change how we analyze attribution, disruption, or harassment?
What a timely question. You know, the medium of expression often accelerates the speed and the scale of disruption. However, it does not alter basic First Amendment mechanics. Unprotected categories of speech, like defamation, fraud, true threat, or harassment, remain unprotected, whether written by a human or generated by AI. For a deepfake or AI flyer to be restricted as a true threat, it's going to need to meet the standard that was articulated in Counterman versus Colorado out of the Supreme Court in 2023, meaning the speaker acted with a total reckless regard for the risk that their speech would be perceived as a true threat. And this is a great case to be familiar with. It's also a pretty high bar. So under Title IX and state laws, including Oklahoma's very recent Senate Bill 1725, harassment must be behavior that is unwelcome, severe, pervasive, and objectively offensive. So if a student, for example, uses generative AI to mass produce deepfakes or impersonations targeting a peer, another student, or maybe a faculty member, the analysis focuses on the impact and intent of the content, and not the tool that was used to build it. The use of AI does not create a lower protection category just because a machine was involved, but AI absolutely matters, and it often complicates pretty significantly evidence and investigations, right? Because you have to look at who prompted it, who edited it, who circulated, who adopted it as their own, and whether or not it was used to impersonate someone so convincingly that it might be fraud, defamation, harassment, or at the very least disruption. So my practical advice is this: don't overfocus on the tool, focus on authorship, adoption, intent, and the harm that results.
Thank you.